I began thinking about the problem of non-human animals in 1980. And then I began working with an organization that became the Animal Legal Defense Fund, of which I was president for 10 years. In 1985, after working for 5 years and also having a private practice on behalf of non-human animals, I realized that I was never going to be able to accomplish anything significant on their behalf because of the fact that they were legal things. And a legal thing is essentially an entity who lacks the capacity for any kind of legal rights. They're the object of the legal rights of persons. And a person is an entity who has the capacity for 1 or 10 or a million or infinite number of legal rights. If you are a person, you're very important. If you are a thing, then you're essentially invisible to civil law. And so I have been working on behalf of things, and the only time as a litigator, as a lawyer that I could win was when it really didn't matter. But if it mattered, then I had no chance of winning at all. So I began working with another lawyer who was an officer in the Animal Legal Defense Fund at that time, named David Faber, and we began to try to understand what the problem was, and we eventually determined that the problem was that our non-human animal clients, if we had them, were not things, and I began to try to figure out how we could make them persons. Now, I spent a few years trying to understand where law came from, where persons came from, where things came from, and I determined that it would take about 30 years of preparation before we'd be able to file the first lawsuits that had some kind of a reasonable chance of success. And that was in 1985, and I predicted that it would take until 2015 before we'd be able to file the first cases. Turned out I was unduly pessimistic. It only took 28 years in 2013. But what that involved was really trying to understand what to do. At that time, no one had written anything. We really had no idea, what to do. All we began to do was try to assess the seriousness of the problem. So it involved, beginning an organization. It involved beginning to write law review articles. I started writing law review articles to try to communicate with my profession. I think I've written 22 law review articles. It involved my realizing that nobody read any of my law review articles. And so at that point, I began to try to understand how I might be able to turn them into trade books, and I began doing that at the end of the 1990s, with Grounding the Cage being the first one toward legal rights for animals. It involved trying to understand who our clients might be, what kind of causes of action there might be, what kind of problems there would be. And in fact, that's what the books were about. The books were really my way of trying to begin to communicate with my own profession about what was coming, what I knew was coming, and which they didn't have any idea at all, because non-human animals had never been persons. They'd always been things. Since Roman times, for more than 2,000 years, they'd always been things. So that's what I worked on. And so, for example, we had to figure out where we might want to file our lawsuits. We decided that we would file our lawsuits in some English-speaking jurisdiction. We looked at every state, and at that point, I was bringing in volunteers, from all over the place, and we spent many, many years trying to understand how to solve all these problems. But one issue was, where are we going to file suits? And so I came up with a list of about 60 different legal issues that I thought might be important, and we then wrote memoranda on these issues in all 50 states and in 20 English-speaking countries, including Israel, and ultimately decided that we would file suit in the American state of New York for many, many reasons. Some of which have turned out to be great, and some of which turned out to be we made an error, or we thought the judges would obey the law. So when it turns out when they don't like us, they don't obey the law, and we take that into consideration. So then we tried to look at what sort of non-human animals should be our first client. And we decided that we wanted to choose non-human animals who, number one, were extraordinarily cognitively complex, and that we could prove it. We could prove it. So as part of my work in books, I got to know, really the greatest experts in elephant cognition and in chimpanzee cognition. Jane Goodall is a member of my board of directors. I've known her for 20 years, but lots of other people as well. And try to ask them, tell me everything that you knew. And I have a degree in chemistry, so I have some science background, and that allowed me to read all of their science journals and then go and speak to them all over the world. So we finally narrowed it, and also we wanted non-human animals who were not indigenous to the United States. We wanted ones who, so that they had not very much economic value, so we were not likely to have an enormous economically powerful forces rise up against us, because nobody cared about really the 3,000 chimpanzees or the 200 elephants or the 10 orcas who were in the U.S., or at least not many people cared. Or at least the people who did care, weren't billionaires or tens of billionaires. So that was not another reason as well. And also, the kind of cognition we were looking for in non-human animals, if we could, was cognition that was human-like as possible, so that the judges would be more likely to empathize with them. So that and other issues went into trying to decide where we were going to file suit and on whose behalf. Then came the cause of action. If you're a lawyer, you have to figure out what you're going to sue for, and that raised all sorts of issues. We eventually decided to bring writs of habeas corpus. Now, in the United States, it's actually habeas corpus means you have the body. It's a very ancient English-derived writ, maybe 800 years old, and it was used when the king threw people in jail, eventually in the 17th century, trying to get them out. But it also began to be used in the 18th and 19th century when slaves, especially James Somerset in London in 1772, used the writ of habeas corpus to try essentially to show that he shouldn't be a slave. And Lord Mansfield in 1772 then eventually said that slavery was so odious that the common law would not support it, and he was freed. And so we actually model our litigation upon the litigation of James Somerset's barristers in 1772. And it's also has been pulled into part of the law of every American state as well, which absorbed most of the English common law when the colonies became free. So we also decided that we would litigate under the common law, not under a statutory habeas corpus, but under the common law. The reason being is that we knew that we were going to be going in front of judges who would not really wish that we were not there. And even Lord Mansfield, at one point, he said he tried to get the parties to settle because he didn't want to decide essentially whether slavery was legal or not, but they refused to do it. So then he said, well, then let justice be done, though the heavens may fall, and decided in the slaves' favor. But we did not, we were wanted to sue under the common law because the common law is the law that judges make. We wanted to be able to go into court and go to speak to judges and say, judges, you're the ones who said that non-human animals were legal things and not legal persons. Maybe not you, maybe your ancestor judge from like 500 years ago, but you judges are the ones who did it. Therefore, you judges, we want you to undo it because we're showing you all kinds of scientific evidence that you've never seen before, and they didn't know about that morality has changed, the relationship of humans to non-human animals has changed. Because we're concerned that if we try to bring a lawsuit under a statute or the Constitution, the judges are going to simply look at it, look into the legislative history, and decide that when the statute or Constitution was drafted, nobody was thinking about my chimpanzee or my elephant as a client. They were thinking as a person, that they were going to be thinking of human beings. Judges, even like Lord Mansfield, are so not wanting to decide the cases like that we bring sometimes, like Lord Mansfield, that they still say, well, why don't you go to the legislature? Go to the legislature. In fact, there's an HBO film about our work, and you can see that happen in the courtroom because the filmmakers got cameras in, you can see a fight that I have with the judge right there, where the judge says, wants to go to the legislature. And I say, because it's a common law issue, and that's you. You have to decide. And you're a co-equal branch. And she said, yeah, I know. Okay, well, if you know, let's forget the legislature stuff. And we're saying, you're a common law judge. This is a common law cause of action. We want you to make that sort of a decision. Now, we also knew that judges in the United States, almost the only time they ever see the common law is when a prisoner is seeking to collaterally attack his conviction through a writ of habeas corpus. In the United States, hardly anybody enslaves somebody else, and some third party comes in and seeks a writ of habeas corpus, a common law writ of habeas corpus, saying, get that person out of there. So we knew that the judges we'd go in front of probably would never have seen a writ of habeas corpus, this kind, and when they saw it, it would be on behalf of a chimpanzee. So we understood that this was not going to be easy. Then, as part of that, we also understood that or what we tried to do was to understand what the values and principles were that the judges in the various jurisdictions we were considering already believed in. Because we think that changing the values of human beings is really hard, and so we didn't want to do that. What we wanted to do was to ascertain what the values of the judges were, and then frame our arguments in terms of those values. So, for example, the ideas of liberty and equality kept coming up again and again, of autonomy, how important judges believed it was for them to protect the autonomy of the citizenry of their state. So we ended up choosing non-human animals who the scientists could file affidavits on behalf of and swear that our elephant, our chimpanzees were autonomous, and give many examples of how they were autonomous. You can also see in the film where I'm talking about that too in one of the other court cases, saying, one of your main jobs as a common law judge is to protect autonomy. It just so happens the only people who have asked you to do that are the autonomy are human beings who want to protect human autonomy. But autonomy is autonomy, and our chimpanzee or elephant clients or whatever, we have proof, unrebutted proof. No one in 10 cases has ever tried to rebut our scientific facts. Now, if they want, they can come in and try to persuade the judge that Jane Goodall has no idea what she's talking about with respect to chimpanzees, but nobody's tried that, and they haven't tried that with our elephant experts either. So at the end of 2013, after the 28 years of preparation, we start filing lawsuits on behalf of every chimpanzee we can find in the state of New York, and the judges, of course, are saying, who are you? And why are you here? So we did not expect, we did not expect to win for a long time. We didn't even expect to get a hearing in front of a judge for a long time. Because when we were seeking ex parte, and the other side didn't even know we were suing them, ex parte habeas corpus, we act writs. And what would happen is that we'd go in to court, we'd say, we want you to issue a writ of habeas corpus against the person who's keeping this chimpanzee captive, and the judge could just say no, and so that's it. We lose the case in 30 seconds. I think we didn't lose the case usually 5 minutes, but sometimes you could lose theoretically in 30 seconds. But it turned out from the very first case, the judge didn't have to give us a hearing on it, but he did. And we found that in case after case, almost all the time, the judges were, something was interesting for them, and they would give us hearings, and then they would say, well, one judge would say, well, I'm not going to be the first to make that leap of faith. And then that same judge, by the way, then tried to block our attempt to appeal what we did, and by not doing a ministerial task. And so we then had to sue him to get into a mandamus action to try to force him to do what we wanted, which once we sued him, and unfortunately for him, the day we sued him, we appeared on the front page of the Sunday New York Times Magazine, and at that point, he got moving. So we ended up filing suits in New York. There are like 300 trial court judges, but they feed into 4 regional intermediate appellate courts, and they all feed into the high court, which is called the Court of Appeals. So just by sheer coincidence, we ended up litigating in all four, and well, actually in three of those four. And what we saw quickly was that, well, first of all, none of them wanted to rule in our favor, but they all began to rule against us, but none of them wanted to rule against us in the way that the others had ruled against us. And so it was clear to us that they didn't like it, but they also agreed with us. Every time we'd lose, we'd go in front of the press and say, they're just wrong. They're wrong. So we lost the first time, they're wrong. We lost the second time, they're wrong. We lost the third time, they're wrong. And then another reason we filed writs of habeas corpus, which the judges hadn't really thought about, is that the idea of res judicata or claim preclusion, whatever you might call it in Israel, meant that we could keep, that doesn't exist in habeas corpus. So we can, if we lose, we say, okay, so we're going to file it again. We just kept filing them again and again and again, which we have the right to do that, and the judges, I think, weren't really ready for that. So we wouldn't go in front of the same judge, we'd then file in front of another judge. And so eventually we actually then brought the fourth time that we brought a lawsuit, the judge issued what's called an order to show cause under the habeas corpus statute, which is what we wanted. For the first time in history, the fourth time we tried, a judge issued essentially a writ of habeas corpus. And the reason it's called an order to show cause is that in New York, if you want to bring the prisoner into court, you ask for a writ of habeas corpus. We did not want to bring the chimpanzee prisoners into court. Maybe they would rip the judge's arm off. We had no idea. So we asked for an order to show cause, which means that those who are imprisoning the prisoner have to come in. And that judge wrote a very nice opinion for us. But finally, and we won every issue until the very last, and she claimed that she was actually bound by a court ruling against us in another way, another part of New York. You can see on the film, we argued that we don't agree with her, but she says, I'm bound, okay, so she's bound. So we then say, well, is she signaling to us that maybe we should try again in front of her? So we actually immediately filed 2 cases in front of her, and it was clear to us that she was not signaling it. She said, this time we didn't have a hearing, she just wrote, basically, get out of my courtroom. I've already said as much something. So we appealed that to the last remaining court, and what had happened in one of the courts is they had said, in order to have a right, you had to be able to have the cognitive ability to have correlated duties. So without duties, there can't be rights, which I think it's fair to say is the first English-speaking case in the history of the world that had ever said that. Since if any of them had ever had children, they might have noticed that their children had rights, even though they could not shoulder duties. Then they realized that, and they put a footnote at the end saying, well, humans collectively can have rights, and we've never understood what that means. So then when we go up to the last intermediate appellate court, then we focused on that, and they agreed with us and say, however, they're human. You forgot that your chimpanzees are not human beings. Therefore, you lose because they're not human beings. And we were very pleased with that because now we can stop fooling around with all these other stupid reasons that the judges are giving and begin to focus on the issue of the real problem, which is a lot of judges, for reasons that they cannot articulate because there are no rational arguments that exist, think you have to be a human being to have a right. And we remind them that at one time in the United States, people kind of, without any kind of reason of being able to articulate it, they thought only white people had rights, or only women had, or only men had rights, or Native Americans didn't have rights. And we say, do we really need to go through this again? Can't we just skip all the crap there and just, all the unfairness and the pain and the suffering? Can't we just kind of go right to it and deal with the argument of why you are wrong? So, however, we did lose, and we had to come out to the press and say, we understand there are 4 intermediate appellate courts, and we understand we have lost in all 4, and we understand we've lost in all 4 on 4 different grounds. So we then appeal, and every single time we had tried to appeal to the high court, and as a matter of discretion, since they only take 5% of the cases that come to it, they had turned us down. On the 3rd time we go up, a judge, Eugene Fahey, issued, the court decides they won't take the case, but then he issues a decision on his own, and he becomes the first, Supreme Court or High Court judge in the United States to give his opinion on the merits of our case. And he thinks it's pretty good. He thinks it's really good. In fact, he then goes through all the 4 cases that we said were wrong, and he says that they're wrong too. And for the same reasons that we had said they were wrong. And he also talks about the fact, he apologizes essentially for voting against us twice, and said, I've been struggling with what you told me for the last 3 years, and I changed my mind. And he says, a chimpanzee, he says, there may be arguments that a chimpanzee is not a person. There may be that they're not a person, not that there may be arguments they are, but a chimpanzee is certainly not a thing. Well, if you're not a thing, then you're a person. So we really appreciated that. And then a month later, another appellate court in New York, in a completely different case that we're not involved in, just kind of notes in passing that corporations and animals are examples of non-humans who have rights. And they cite our case, which they had thrown out. So we never quite understood that. So while we're doing that, we then bring suit on behalf of an elephant, which we're doing right now on behalf of Happy the elephant in the Bronx Zoo. So we tried to file the lawsuit in the part of New York, which was like near Niagara Falls, where the Intermediate Appellate Court had said animals can have rights. And the Bronx Zoo, which was like 600 miles away, or 1,000 kilometers from the Bronx Zoo, they didn't like that, and they persuaded the judge who issued, by the way, the second order to show cause, the writ of habeas corpus. And we then had a huge fight because we wanted to stay in the Bronx, and we wanted to stay way out in the boonies near Niagara Falls. And the judge said, I'm issuing the writ of habeas corpus, and then I'm going to send it to some other judge in the Bronx. So we show up to the Bronx, and you have to understand that when in all of our trial courts, the whole thing, the longest argument we ever had was 90 minutes in front of the first judge who issued the writ of habeas corpus. This judge in the Bronx, 2 months ago, walks out, and she is completely fascinated by what we're doing. So we are now in the 11th hour of argument. So we argued for 5 hours in September. We argued for 5 more hours in October. On January 6th, we're arguing the next 5 hours. And that alone shows the progress that we are making. She is really interested in what's going on, has an enormous number of questions, and that doesn't mean we're going to win because an appellate court above her has said that only humans can have rights. But she didn't just throw us out for that reason. And we spent a lot of time trying to persuade her that, as lawyers would say, that them saying that was dicta. In other words, it wasn't the holding of the case. They had thrown us out on another ground, which didn't apply to Happy the elephant. And now all the rest of the stuff they said that only humans had rights, that was what lawyers would call dicta or obiter, and she doesn't have to pay any attention to that. And meanwhile, we've been bringing in all of our elephant experts who've been doing a great job through affidavits, and we have just been fiercely arguing it. And that doesn't mean we're going to win, but we want to get back up to the highest court, the Court of Appeals, and hope that maybe the one judge who really likes what we're doing, maybe he's brought somebody else along with him, and maybe we can get the 3 votes that's finally needed to get up to have the High Court take our case. Because he chastised his colleagues saying, this is really important stuff. This is of great moral importance, and it is a duty of us courts to at least decide the case. So meanwhile, we've had to start over again in Connecticut. We brought a lawsuit on behalf of elephants, and those judges were going, they don't know what to do with us. So we've been having a kind of a grim time in Connecticut, but I'll be back in court at the appellate level in January, and now we are getting ready to file lawsuits in California, in Colorado, and I think we brought about 10 of them now, and we really are understanding what the problems are, how we deal with it, and we still like habeas corpus. We still think that habeas corpus brings it takes care of a lot of issues, of technical legal issues. Like we don't have to have standing. We can keep filing it in case we lose. Because probably in the United States, unlike other places, the loser does not pay the winner's attorney's fees. In the United States, everyone pays their own attorney's fees. But we don't have any attorney's fees. So we don't have any. And so the other side, if they have to pay attorney's fees, that's just really too bad for them. And so we actually focus on trying to win pieces of cases and then keep putting the cases together. And then if we lose, we don't care. We just come back and try to figure out what was it that how we might be able to change. Should we change our client? For example, we thought, maybe chimpanzees are too close to human beings. Maybe that makes judges feel creepy. But everybody loves elephants, so we started filing a lawsuit on behalf of elephants. And the whole object is to get judges used to the idea that non-humans can also have rights. There's no rational, non-arbitrary reason that humans only, but only humans can have rights. And part of what we're doing is just getting them used to the arguments, having them hear the arguments, and slowly winning pieces of them. And every now and then we have courts like this the one Supreme Court judge who agrees with us. He says, I'm thinking about this, and you are right. So anyway, non-human animals are on the verge of beginning to get legal rights in the United States, I guarantee. And I don't know how long it's going to take, but it's going to happen, and it will go beyond elephants and chimpanzees, and we will be at the forefront of that. So thank you very much.